In a Texas divorce, there are a couple of different types of custody. We actually call it conservatorship in Texas, so sometimes you may hear the term conservatorship. But there's joint custody or joint managing conservatorship, and there's sole managing conservatorship, sometimes called sole custody. Joint managing conservatorship is the standard in Texas. It's presumed that joint custody is in the best interest of the children. And the term conservatorship and custody really revolves around the rights and decisions that each parent has over their children. Now, this is not the day-to-day stuff. This is not what time the kids go to bed or what food they eat. That you deal with in your household, and your ex deals with how they want to raise the kids in their household. These are big picture decisions, important decisions, things like invasive medical that is not involving an emergency, things like psychiatric and psychological decisions or educational decisions. Who will file a lawsuit if the kids are injured in an accident? Who has legal rights to do that? Also, things like, can my kid go in the military before they're 18? The parents can decide whether to allow that. So these are really big, important issues that parents can have joint decision making on. And that's what joint conservatorship or joint managing custody is. In a sole custody situation or sole managing conservatorship, one parent has the exclusive right to make all of those important decisions. That's not very common unless one parent is either completely incapable of making those decisions or just really doesn't want to be involved, which is rare. And usually the situation where they're completely incapable of making the decision is either that parent has a psychiatric condition or they've got substance abuse issues, maybe they're in jail. It's a pretty rare situation where that parent is going to have their rights to decision-making in their children's lives taken away. So standard custody conservatorship in Texas is going to be joint. A lot of decisions around your children in a Texas custody situation deal with the term the best interest of the children. That is a term that is completely undefined, but there's a lot of elements that go into it. And some of the elements that go into determining what's in the best interest of the children is things like making sure that the children are cared for, that there is financial support to make sure that the children can live a quality life, that they have a home, that they have a safe home, that they have good education, that they have health insurance and dental insurance to take care of their medical issues when they need it. But the bigger picture is who is looking out for the children's mental and emotional health? Are they loved? Are they safe physically? And are they healthy? And when we're looking at the best interest of the children, the courts are going to look at both parents and their involvement in the children's lives and make a determination, if the parents can't agree, on who would be the best parent to be primary in their children's lives to make sure their child's best interests are met. To show that you are looking out for your children's best interests, it's really important to document that in some way. Things that you can do to document your involvement in your child's life and your ability to look out for their best interest are things like, making sure that other people in your child's life know you, know what you do with your child, teachers, doctors, friends, family members, other children's parents that may know you from activities, that sort of thing. You want to show the world, the judge in particular, that you are involved, and having other people that can testify to that will be helpful to you in showing your involvement in your children's lives. Once a custody order is in place, It's always possible to change it up until the time that your child turns 18. A lot can happen in your kids' lives from the time that you get divorced until the time that they become legal adults. And the family courts can still be involved in making changes to custody arrangements for the best interest of the child if something changes that would require a modification. So it's not set in stone. The courts can always make changes. If something happens to one parent or the other that perhaps now that parent would be unsafe for the kids to be around, there might be a change of custody. Sometimes there might be a swap of custody if a child, usually an older child in their teenage years, states a preference and said, hey, I don't want to live with my mom anymore, I want to go live with my dad, or vice versa. That child's preference is taken into account. They don't get to make the final decision. The court still has the final say. But if they strongly feel that they want to live primarily with the other parent, that is a strong consideration in making a change in custody. A lot of people come to us wanting to modify their custody orders, and a lot of times it's not necessarily worth it for them to do so. We really appreciate talking to parents in those situations to help guide them, because sometimes when you're having issues with another parent or the kids are having issues, there are other things that you can do to help the situation that may not involve going back to court. Modifying a custody order is not easy. You have to show that there's been a material and substantial change in the child's life or in the life of the parent that would justify that change. And so just because you feel like you want more time with the kids, that's not a good enough reason to make a change. Or you may think, well, I don't like how that other parent is managing this situation, and I think I would manage it better, and I should now be the primary parent. Again, that may not be enough to make a change. And a custody battle at that point can be very expensive. So you want to make sure that you have really evaluated the likelihood of making the change that you want with a legal professional so that you don't just waste your money trying to modify a custody order that may not be capable of being modified. In a Texas divorce, you will have a geographic restriction that says you're going to live in a certain area. Usually it's the county that you live in. Sometimes it's the surrounding counties as well. But that's going to limit you from moving out of that area as long as the kids are under the age of 18. And the reason for that is to allow the other parent to have an easy time with visitation. If you were able to pick up and move to Alaska or Hawaii, now the other parent is going to have a really hard time coming to see the kids. It's going to be expensive. And we want both parents to be involved in the children's lives. So if you have that geographic restriction, you're not going to be able to move out of that area unless the other parent picks up and moves somewhere else. So if they move out of the geographic restricted area, most orders will say then that geographic restriction is lifted and the parent who was restricted from moving can now move anywhere they want. If you're a parent that has visitation, you can always move wherever you want. Just keep in mind that if you move out of the area that your ex-spouse is required to stay in, you could cause a lifting of that geographic restriction and they may be able to move elsewhere. But as a visiting parent, you can move wherever. You just may have a change in your custody schedule to accommodate that. If you have any questions about custody or modifying custody in a Texas divorce or in a modification after your divorce, please give us a call at DeFord Law Firm.